Hello and welcome to Aston Originals. I'm Sam. Let's get straight into the conversation. Notably, an article holding a placard outside court isn't illegal, judge rules. Is that the best British democracy has to offer? Now, the UK High Court recently dismissed the case against environmental activist Trudi Warner, who was referred for contempt of court in March 2023. Civil liberties campaigners hailed the decision as a huge win for democracy. But is it? Asks Dr. Graham Hayes and Dr. Stephen Camis for the conversation. Now, Graham is an expert in social movements and protest at Aston University. You can find him on X at Graham Hayes and in the studio as he's joined me here today. Hello, Graham.
Hi there.
You spell Graham weirdly. Would you like us just to remind the viewers how you spell that if they do want to find you on X formally?
The correct way, which is Graeme.
Excellent. Right, now let's have a look at the background here. Trudi Warner has stood outside the Old Bailey, England's most important criminal court in central London, with a sign that read, "Jurors have an absolute right to acquit according to their conscience." She did so at the start of a trial of climate activists who've been charged with public nuisance for obstructing traffic. And I think Helen's just going to pull up the photo of her, which is part of your conversation article, so I hope we have the rights to use that. If not, then it's going to cost us a few quid. But just explain what's going on here, because what is the problem?
Yeah, that's right. So it's important to say that this image is a recreation. It's not taken on the day itself. But you'll remember that back in September 2021, a number of Insulate Britain activists sat down on a series of motorway junctions and also a number of major routes in London to protest the climate crisis. And they were arrested and they were charged with public nuisance. It takes a while for things to get to court, perhaps more of that later. In England and Wales at the time, and when they came to court, they were told by the judge, Silas Reed, that they were not able to mention the climate crisis in their defence. So they weren't able to explain to the jury why it is they did what they did. And the judge threatened them with contempt of court for if they did say anything about the climate crisis. And in fact, two of the defendants were sent to jail for 8 weeks for actually defying that order and doing so. So that's the context. And during this trial, there's a whole series of trials, but during one trial in particular, Trudi Warner, who you can see in the image, took this, made this banner herself, made this kind of placard, and she stood there and she milled around and she went inside the court at the time that the jurors were arriving for this trial. It was brought to the judge's attention, and he decided that she should be referred for contempt of court. So what is she doing? Well, she's reminding jurors, if she can, because it's not sure that the jurors actually saw her, that there are ancient rights. This dates from 1670, and it's that if you're a juror, you cannot be prosecuted for not finding according to the law. What does that mean? If you're a juror, you're able to use your conscience to decide rather than just following the legal direction. And that applies to all sorts of criminal trials.
So the whole concept of jury equity is a large part of the article, and its historical significance, as you just mentioned there, actually in the context of English democracy, and especially in relation to that right to protest.
Yeah, that's right. So, I mean, this goes back to 1670. So it's just this idea that you cannot be compelled to find as the court directs you. You can use your conscience. Of course, we have a whole series of cases in the courts at the moment where conscience is really central to this, because we have a number of protesters, and this happens for climate protesters, but all sorts of other protesters, animal rights protesters, Palestine Action Group protesters, who are committing acts for which they're being prosecuted and find that they don't have a defense in law. In other words, there's no legal basis for them to be found not guilty. And this is something that's happened over the last 5 or 6 years. Defenses have been removed systematically from protesters in these situations. And therefore, all that they can do is explain or try to explain to the jury why they did what they did, and hope that the jurors will find according to their conscience, because they're pleading not guilty, whereas they accept the facts that they're being prosecuted for. And that's the key thing. Generally in trials, you find that, people don't accept the facts. They say, no, I didn't do that, or no, it was somebody else, oh no, you don't understand. In this case, and they're saying, yeah, we did that, and we did it for this reason. Therefore, they seek to explain to the court why they did what they did, and hope that the jury will say, well, we're not going to convict them because of that.
And so what were the key arguments then presented in favour of Trudi Warner during her case, and how did the High Court's decision impact the broader rights of protesters?
Well, I think, the key arguments are fairly straightforward on. I mean, I say this went through a legal process, and the Solicitor General referred her case to the High Court. What's the argument? Well, what she did wasn't illegal. In this case, she's basically taking text which is on the wall of the Old Bailey.
That was on my notes, actually.
Yeah, no,
Warner's sign is paraphrased of the text on the plaque.
Yeah,
it's on the Old Bailey.
So it's not the exact words. It's literally on the wall of the court, and so she's reproducing that. So
I guess is that what this is here?
That's right. So we can see here that that's actually, and it's not the exact text, but it's it's a paraphrase of the text. So what she's doing is simply taking something that's on the wall of the court. But of course, she was referred for jury tampering, which is something that we might expect to be threats to jurors, something we might associate with violent crime and so on and so forth. And of course, the High Court found that this was, if I can paraphrase, that this was ridiculous and absurd, and there was no case to answer, and that what she was doing was, as you say, actually there's a really key phrase here, which is she was acting as a human billboard. And one of the things that we argue within this is, well, what precisely does that mean? If we think about this as a victory for protest, is that what type of protest really here is being recognized, and what are the limits of that form of protest?
So can you have a look just with us now, the potential implications of the court's reasoning, particularly regarding the balance between upholding the law and then protecting democratic freedoms in protest context, which I suppose obviously you would have written extensively about.
That's right. Yeah. So look, I think the first thing to say is that look, this is a victory for protest rights, but it's a very limited one. In other words, it doesn't do anything to reverse the direction of travel over the last 5 years or so, which is a form of what's known, I think, as democratic backsliding, a systematic removal of rights of freedom of assembly and freedom of speech rights, and this isn't done in a formal way through Parliament, and this isn't like as withdrawing from Britain withdrawing from the European Convention for Human Rights, but this is limiting their application, limiting the capacity of protest defendants to be able to call on these in court. And we can see this with this removal of defenses that has been systematic. So it doesn't do anything about that. I think that the second thing to underline with this is that still you're not able to tell jurors within a trial that they have that right to decide with their conscience. And so if I can give you an example of that, I was at the trial of Gail Bradley, who was one of the founders of Extinction Rebellion. She co-founded it back in 2018, and in 2019 she took a small hammer and smashed a plate of glass outside the Department of Transport as a protest against HS2. Well, that didn't come to trial until 4 years later. So this is October 2023. There'd been a first trial which was aborted in July 2023, but this trial was at Isleworth Crown Court in July 2023, and she wanted to tell the jury that they had a right, an absolute right, to decide with their conscience. And the first trial was aborted because she said it, and the judge said, no, we'll stop the trial. So we had a second trial, and she was gearing up to say it, and 3 times he sent the jury out to tell her she couldn't say it. Another 15 times he stopped her directly in the course of the trial to say, no, I think if you're going where I think you're going, You may not do it, and there will be consequences. So throughout this trial, you could feel that Gail Bradley over and over again was trying to say, and you have this right. You have jury equity is on your side. And the judge continually intervened. And the threat was that if she did it, what he would do was abandon that trial and have another trial without a jury, which again is typically what happens in organized crime. I mean, it's very rare, but it doesn't happen in terms of a non-violent protest activist who's done a small amount of criminal damage. So again, that doesn't change. Jury equity, it's still, we call it kind of a dirty secret. You're not allowed to say it in court, even though that might be the only thing you've got to rely on. You can't say it. And then I think the third thing to say about this is that, you know, she referred to herself, her lawyers referred to herself, the court referred to her as a human billboard. And, you know, there's a group called Defend Our Juries, which has organized very much in the wake of this. And we've been to a number of trials. So Gail Bradley's trial was one of them back in Isleworth in October, where in the morning when people are arriving in court, you see a number of activists sitting outside with exactly the types of billboards that you can see, exactly these placards. Some of them have got nothing written on them, and they're completely silent. And this is another thing. So a lot of this is about silencing of some form of democratic voice to be able to say, we've got a problem. It's a serious problem. I'm doing this because there's a problem, and something needs to happen about this really quickly.
Really strange, because it's almost like I can't really describe it, but it seems like, you know, when you can't say Voldemort in Harry Potter, it seems exactly like that.
Yeah, it's exactly like that. But it really is. Or if you think about the Scottish play, you're not allowed to say that in the theatre. And so you can't say. But one of the things that seem to be very supported by the High Court in this is, of course, Trudi Warner herself was completely silent. She didn't engage anyone. She didn't intervene. She didn't go up to anyone. She didn't tell anyone that you could do this. So one of the things that is actually quite approved of in the court's judgment is that essential passivity about what she was doing, which makes you think two things. One is that how completely almost off the wall it was that this woman standing outside a court with a placard saying what's on the wall of the court and not intervening gets referred for jury tampering. And then the other thing is, well, what if she had said something? What if she had engaged? Would the High Court have found in the same way? So it still feels as if the type of protest that can be found to be legitimate in the courts is this silent, non-intrusive, non-disruptive, non-engaging protest, which again leaves us perhaps in not a particularly good place.
I suppose actually for Gail Bradley, she must be thinking, I wish I'd done a full dinner set, and the whole thing would have been scrapped HS2. So one dinner plate binned off the north.
Indeed,
How
yeah.
Interesting.
You know, and it's interesting in that case as well about whether what we didn't know in the court at the time, because I was observing it, was whether she was going to push it all the way, and in the end, that she didn't. But you know, in that case and others, each of these is defining what you can do in other cases, and it really is, I can't stress enough, and I've said it a couple of times, a systematic removal of defense rights for these types of protest actions.
Just looking ahead, what are your thoughts on the potential trajectory of protest activism and legal advocacy in the UK as well, considering the complexities that, you know, you've been highlighting for the episode today by this Warner case, and then the similar legal challenges that you brought up as well?
Well, I mean, I have to say, I don't think in the near term that things are going to change. I mean, I know sometimes people say things, well, if you don't enable people to protest non-violently, then what's next? What do they do next? They head towards violence. I don't think that's the case at all, to be honest. I think when you look at the types of activists who are involved, they're not suddenly going to turn from being a non-violent activist into someone who will commit acts of horrific violence. It's just not going to happen. People aren't going to plant bombs or do anything of this kind of stuff. And in fact, we did a survey of an Extinction Rebellion protest called the Big One, which took place just about exactly a year ago in London. And, you know, we asked them about the types of actions they would consider. And it was just overwhelming non-violent actions. I mean, barely anyone was up for anything harder than that. So that's not going to happen. Equally, two other things I suspect aren't going to happen. First of all, we're not going to get suddenly a much more liberal government, whatever happens at the next election. I think we can see already, I think we've seen enough already to understand that if Keir Starmer is elected as Prime Minister with what is likely to be at this stage a Christian majority, that government will be as instinctively authoritarian as the current government. And equally, the multiple crises that these activists are protesting against aren't going to go away.
Sorry to interrupt. Did you say that because of the way that you see there being a stonking majority? I mean, something out today, and I don't want to age the podcast too much, but 571 Labour MPs versus 13 for the Conservatives. But you have a leader in Sir Keir Starmer, who is a previous director of public prosecution. So, you know, he knows his way around the courtroom. Do you think that doesn't hold as much as having a lot of people on that one side of the coin?
I think as a former human rights lawyer, it's interesting to look at Nicola Sturgeon and Keir Starmer. Nicola Sturgeon was also a human rights lawyer and maintained that sense of identity as First Minister of Scotland. It's very, very hard to detect that within Keir Starmer. So I think, you know, perhaps the size of the majority is, I think it probably is important, because then there is security which comes with it, and it doesn't matter what we do because there's no opposition effectively. But I do think that what we're dealing with is somebody who is instinctively an authoritarian and will continue to pursue those authoritarian politics, not least because I don't see how they are providing us with an answer to these ongoing crises in public services, in climate change, in Israel's ongoing onslaught in Gaza. The positions that are adopted by the official opposition at the moment are very difficult to dissociate or distinguish from those adopted by the current government. So without those answers, protest will continue. And what do you do? What do you do if people are protesting and you're not offering a solution? Well, the obvious answer to that is crackdown after crackdown after crackdown. That's what we've seen. That's what I expect us to see. So I think, where will that lead us? Well, one thing it might lead us is to more people being sent to prison, to longer prison sentences for those who are being sent to prison, and to, I suspect, a greater sense of impending crisis and a loss of legitimacy in the future government.
Really interesting. I want to ask you just one more question, which I would normally ask at the beginning, but I feel like we have to get through this part and this whole thing first before it. And why did you write it?
I suppose we write it because we think this is just a really, really important issue. That strongly feel. One of the things I went to a meeting of some Just Stop Oil activists a couple of years ago, and one of the things that one of the activists said really stuck with me. And you know, I've been teaching this for ages, but the way he put it in a really stark case, he said the right to protest is more important than the right to vote. And one of the things I thought was really interesting about that and makes you think is, of course, the right to vote stems from collective action, from collective protest action. And I think this is really important to understand at a time when protest is seen as being increasingly illegitimate, or only legitimate within certain very, very constrictive circumstances, is that our democratic system rests upon the idea that we have some form of agency as individual citizens. And that agency is being systematically stripped back, and any form of protest is seen as being illegitimate. So for me, this is something which is powerful, important, significant, urgent. this is really about what we understand as living in a liberal and democratic society. And when I talk about this form of democratic rollback, that's really important for us to think, is this what a liberal democracy looks like? That somebody such as Trudi Warner standing there with a billboard outside the Old Bailey, repeating what's on the words of the walls of the Old Bailey, is referred with a potential prison sentence for jury tampering? Is that what a liberal democracy looks like? And this is just, the latest, most extreme case. I'm sure we'll be back here again talking about others.
I'm sure we will be. Graham, it's always great to catch up with you. I think it's the first one we've done in person, actually.
Yeah, it is.
I'm sorry you've come to the hottest
yeah.
studio in the world.
Right.
So if it looks like we're melting, that's the reason. But do go and check Graham's articles out on theconversation.com. We will put the links to those in the description. But otherwise, make sure you are following us on X at Aston Originals, and also make sure you subscribe to us on YouTube at Aston Originals.